Atlanta News First Plus starts now.
And welcome to our continuing coverage of the Colin Gray trial. Now in day 2 of coverage, we've been bringing you gavel to gavel here on ANF Plus. I'm Maria Moreau, and we are waiting for court to resume at 12:45 with witness testimony and arguments from both sides. But while the jury is on a lunch break, we wanted to catch you up on what these past 2 days have entailed and where we are with the focus today. And to do that, I want to bring in our guest here, criminal defense attorney Joshua Schiffer. Josh, you are not connected to this case in any legal matter, but we did want to bring you on as a legal expert and a guest here on ANF Plus to kind of break down what we're seeing, because this is a case that has largely captured national attention, and it's very unusual to see in America's courtrooms that a parent be criminally held responsible for their child's actions.
Yeah, it absolutely. It's not absolutely novel as it's the first time we've ever seen it, but really, it's kind of the second time. Many viewers will remember the Ethan Crumbley shooting up in Michigan from the last couple of years. That case where it also involved charging the parents for allowing the child access to firearms, not preventing the horrible murders that Mr. Crumbley was then convicted of, eventually did result in the first national conviction of his parents. And that case is slowly winding its way through the Michigan appellate court system. This is Georgia's turn at trying that same expansion of prosecutorial duties and obligations. To catch everybody up, we had a absolutely tragic massacre of children and adults with many people injured at Appalachia High School. This was allegedly committed by a young person, Colin Gray, less than 16 years old. And the real sticky issue in this matter is that Mr. Gray's parents had been visited by law enforcement and other agencies during the previous couple of years and told, hey, something's going on with your young man. We're getting these complaints about things that he's saying, some of his actions. There was discussion with law enforcement, and nothing really changed. Now, that wouldn't have been a problem except that young Colin Gray then committed what appears to be just a horrific act of violence using the firearm that his father, the defendant in today's trial, Colin Gray, not only made available for Colin Gray, but there are actually allegations of encouraging the use, the connection over the firearm, and providing additional firearms for Colin Gray, which obviously in retrospect now was a horrific development. This is the first time in Georgia a parent is being tried and charged and prosecuted for the actions taken by their child. And the criminal responsibility theory is based on the cruelty to children in that by allowing his child, Colin Gray, access to these ultra-hazardous instrumentalities when he knew or should have known that was going to lead to harms, that's the criminal action. As the state put out in their opening statement yesterday, the focus in the trial is on Colin Gray's actions, not Colin Gray's actions.
And really that is the focus of what both sides are arguing is, to what extent should Colin Gray have known or have taken more steps to prevent a deadly mass shooting of this nature. And I know that the prosecution has come forward and said, we have 3 years worth of warning signs that we feel should have been enough for Colin Gray to step in. We have the defense saying that there are many parents who, gift their young people firearms, as is in our country, the Second Amendment rights, that there are parents who, as the defense has pointed, Colin Gray trying to be an involved father, and to what level should we hold parents responsible for their child's actions? So I kind of wanted to focus on the prosecution side in that sense and those warning signs and get into some of that. What is it going to take to convince a jury, this jury in particular, that all of the signs were there and Colin Gray had enough information to predict and interject into something like this?
I think that establishing the factual scenario is going to be pretty smooth, and that's actually what we've witnessed here on day 2 of testimony. This morning's witnesses, they're on a brief court break for lunch right now. This morning's witnesses were all very straightforward, factual, scene-setting witnesses. There was very little cross-examination, no raised voices, no conflict or intensity, as we had people from first responders as well as victims come up and explain the facts as they understand them. So when it gets to how the state is going to establish the responsibilities and duties of Colin Gray, they're doing the right thing. They're going through this 3 years of visitations, of warnings, as they laid out in their opening statement, that will show that Colin Gray and the family were advised, noticed, pointed out multiple times that their son had done things and took actions that caused others to notice and to reach out. These are people outside of the Gray family. That's a big red flag for the state. And the state is going to lean on the idea that, hey, what kind of parent are you if the police come to talk to you about your son and violence and you really don't do anything? Or worse, as the state indicates, you actually leaned into that relationship, used it as apparently a bridge to connect with your child, did not take the appropriate warnings, and that resulted directly in the violence that we all saw. That is a very logical, meaningful, and I believe effective pathway for the state to establish what the state believes is Mr. Colin Gray's duties. Because is there a duty to warn? Is there a duty to stop? Certainly there is. It's just not defined. There's not a statutory trigger where, okay, if you are visited 2 times by the sheriff, that's when you are deemed criminally culpable and knowledgeable. No. The problem with this case is that without a strong factual law and triggering concept where this, after passing this red line, that's when the law is broken, it comes down to a jury to determine what's reasonable and what's not. That reasonableness standard is at the crux of many jury trials, because what are jurors at the very end? They're the factual determiners. They listen to the evidence and decide what was reasonable, what wasn't reasonable, what actually happened. That's the core role of a juror, is to cut through all the conflicts in evidence, the different bits of testimony that conflict with each other, but also how to determine the weight and sufficiency of the testimony that they hear. And they're going to be weighing exactly what happened, what the interactions were, and whether the knowledge that Colin Gray was obtained during this 3 years rose to a level where he was required to take action, otherwise it was criminal. And that's where it gets really sticky. The defense is going to have a field day with the idea that Mr. Colin Gray didn't commit any shootings. He never pulled a trigger. He never pointed a weapon. And as the defense put out in their their opening, Mr. Colin Gray is on trial for what his son did. And that is a tough concept to lodge in the gut of a juror who is watching someone be prosecuted, potentially thrown in jail, 29 charges for something that they admittedly didn't actually take an active part in, but are trying to be held criminally responsible.
Yeah, I mean, we're talking about a lifetime in prison, potentially, if the charges do stick, if he is convicted. And it is also interesting that we are seeing the trial of Colin Gray before we see the trial of Colt Gray. The father and son obviously being tried separately, but how might this impact Colt Gray's case?
That's a great question, because generally the court sets the calendar issues. The court controls calendars. It's part of their inherent discretion. It's one of the great powers of being a judge, is you get to decide what you do with your days. Colt Gray's prosecution is moving forward, but as explored in a hearing in December, his mental health evaluation, key to any defense when involving a case involving a child in violence like this, that mental health evaluation had not been completed. And that's because they're doing state mental health evaluations. I assume they're also going to do some private personal evaluations, but that process takes a lot of time. And when that was announced to the court, the judge said, all right, then we're going to punt Colt Gray's trial until later in 2026. That doesn't stop the case against Colin Gray. Judge Prim is a judge that moves cases. He does not want to belabor this impact on his community. He understands that this is an important case and the public demands that the court do its job and process issues of this importance. So that's what he's doing. And he set the schedule. We saved a bunch of time on voir dire and jury selection, which was originally scheduled for a couple of weeks. They accomplished it on Monday, Tuesday, and Wednesday, heard pretrial motions Thursday and Friday, and started off first thing yesterday with a trial that I could see lasting 1 or 2 weeks. Could go a little bit longer depending on how big the defense wants to make the case. But I believe the state's case is going to wrap up in pretty efficient manner.
And I'm curious if we could see this kind of play in the favor of the defense, because the judicial system believes that you are presumed innocent until proven guilty. Colt Gray's trial has not started yet, so he holds that presumption. And we're hearing language in Colin Gray's trial of almost discussing Colt Gray as if a conviction has been had already, even though it hasn't. So could a defense come forward and say, we need to uphold the language that Colt Gray has not had his day in court, that he is not guilty of what he is being accused of until that happens?
Yeah, it's absolutely something the defense can choose to make hay out of. It all depends on where they want to call attention to their case. At the same time, Colt Gray not being in the room is the giant empty chair. And the defense is going to very easily point and say, listen, everybody, we understand the horror and the trauma and everything that Colt Gray is responsible for, but that's Colt Gray, and he's not here today. He's not on trial today. His father is. It also raises the possibility, would Colt Gray appear at the trial of his father in some sort of mitigation or exculpatory role? He's allowed to do that. Whether his lawyer would allow that, whether there would be discussion about whether he's going to take the fifth, but talk about an angle or application of facts and testimony that could dramatically change this case. If Colt Gray, hypothetically, was to appear and provide clear testimony about, nope, I hid all of this from my parents, I talked it all down, I'm a sophisticated teenager, dad and mom knew nothing, I was sneaking around, man, not saying it's beyond a reasonable doubt, but that certainly would land with a lot of jurors going, hey, teenagers and parents, there's not a lot of truth and honesty between them in some relationships, especially troubled relationships. And we know that Colt Gray had some mental instability, some other troubling aspects, because that's why law enforcement had come and visited the family so many times. That's why there had been so many complaints about Colt Gray and his behavior. So Colt Gray is a giant impact on this case. We just don't know how that impact's going to end up being deployed.
Yeah, certainly. And, we heard a lot of testimony from the shooting victims talking about that horrific day. And I'm curious, for a jury that is listening to this and focused only on Colin Gray and this trial surrounding the father of the accused shooter, how is that impactful to them when their priority right now is determining what level of involvement does Colin Gray need to be held accountable or acquitted of?
The impact of the testimony is high because of its trauma and its visceralness and its concreteness. You're literally hearing from these young people now, 16, 17, 18 years old. We don't obviously get to see their faces on camera, but their voices in describing what they went through, man, you can't look away. That's the kind of testimony that is always going to land heavily with a jury. What the jury does with that testimony, that's up to the advocacy. Is this a pile-on from the state trying to bury someone who really wasn't responsible? Or was this the very appropriate assignment of blame against Colin Gray? Because Colin Gray was in a position to prevent this by taking firearms away from a juvenile. And that's really at the core of what the state's putting forward without being so blatant. Colin Gray His lack of action, his refusal to be responsible, that's what allowed this crime to take place, and that's why we're prosecuting him. That's the heart of the state's argument. And it's, as part of that, had Colin Gray simply said, my mentally challenging, warned about son shouldn't have unfettered access to high-powered firearms and ammunition, well, that's kind of the core thing. And how angry are you as a juror? Or are you upset that, hey, this is the state trying to blame a parent for something they couldn't control? Because, hold on, were you a teenager? Were you controllable? Did you follow every single rule, piece of advice, guidance? If the state tries too hard, it could really upset some of these jurors. And that's the delicate artistry that we're seeing on display with some top-notch lawyers as well. They did not call in the JV crew for this. Mr. Hobbs and Mr. Berry for the defense are extraordinarily good lawyers. Mr. Berry is a hero to many people on the defense bar, and the state obviously is being represented by passionate, impeccable professionals.
And I want to talk about this on a more broad level, is we are watching this closely, as many are. If Colin Gray is convicted, what precedent would this set for future cases involving parental responsibilities, specifically in mass shootings that we see around the country?
Well, it opens up new fields for the state to pursue. This is an expansion of state prosecutorial authority and power. This is getting into a existing but novel area. We really don't go against parents for the quote unquote things their kids did. Does this signify a change? I know the legislature is watching this. The Georgia legislature has previously tried to regulate the storage of firearms by passing some tax incentives, but it's very difficult to write any law that involves guns in Georgia, as well as the rest of the Southeast and nation, because the Second Amendment is so sacred to Georgia residents. I'm a firearms owner. In fact, I've gifted a firearm to a minor before in an appropriate adult, responsible manner where firearms are locked up, ammunition's not available. But how does the state really respond to that? Are we going to see the legislature take brave action involving the regulation of firearms and other ultra hazardous instrumentalities? Or are we going to see a pathway with more explicit criminal responsibility being assigned to parents for the actions of their children? We sometimes see that in the DUI and automobile universe, where the parent has allowed children or minors to party at the house and then an accident happens. In the civil world, it's pretty straightforward to pass on this contributory negligence, whether intentional or not. But in the criminal universe, this is a little bit more rare. It almost acts as the conspiracy statutes, which are very unfair, according to many, including me, because just mere knowledge can now make you guilty, even if you didn't do anything to move forward with a criminal plan, such as felony murder. Your mere presence is enough to trigger criminal culpability. And I don't know a lot of people that like to go to Georgia jails unless they've broken the law.
Fair. This is day 2 of the Colin Gray trial. We have several more days, several more testimony arguments still to hear, and evidence that is going to come to light. Watching this as closely as the rest of us, Josh, and with your legal expertise and background, what are you looking closely for?
I want to see how Jimmy Berry and the defense is going to lay out the more statutory and legal arguments for why the state should not be able to proceed on this path, because this case is destined for appellate review, especially if there's a conviction, but even an acquittal or some other ruling. This is the kind of case that prompts the state to pursue appellate rights when very often they wouldn't. So I really am interested in the academic dissection of the case as much as the emotional impact. A lot of the press is going to be focused on the loss of life. and the emotional, almost histrionics that people have when we talk about mass shootings. But academically, that's where the real interest is going to drive. This case will be the basis for legislation in the future. It just depends on what perspective you want to view it on. The groups that get together and advocate for more aggressive firearms control and regulation, this is going to be a case that provides them good arguments. For those that fight against the infringement on Second Amendment issues, this is a rallying cry for many of them that will be used to generate funds and support, because any legislative or legal action against firearms owners prompts a response.
We're talking with criminal defense attorney Joshua Schiffer, joining us here to provide analysis on the Colin Gray trial. We're going to take you back inside of the courtroom. Lunch or recess ends at 12:45. We expect court to pick back up with continued testimony and arguments from both sides. In the meantime, you're watching A&F Plus. We're going to do analyses and deep dives just like this with legal expert Josh Schiffer here with us each day of trial at about 12 at noon each day, Monday through Friday. So make sure you join us here on A&F Plus, where you're watching as we break down day by day, gavel to gavel, of the Colin Gray trial. We'll be right back.